Well, hey folks, we're back, and this time we're talking about Chapter 3, which is going to be about the legal background of the hiring process. And this is going to be presented in two parts rather than three. Part A is just some general ideas about the kinds of workers that we might have, the classifications of workers, and mostly it's going to be just some general kinds of things, a few questions potentially for the test. Part B of Chapter 3 is the specific laws that we've got to be thinking about. And we're going to spend a little bit more time on that one than we do on this one. But to get us going on the overview of our types of workers, let's remember that first of all, there are a lot of different types of relationships. When we tend to think of workers, we probably tend to think of full-time employees, but there's a lot of other types of people that we might have working for us or doing work for us, with us. But we start with the term employee. What is an employee? Employee is a person that is engaged with us for a particular thing in exchange for some trade-off. And typically the trade-off that is made with employees is that you will do these tasks, you'll do this work, you'll put in these 40 hours, whatever it is, in exchange for or in trade for some payment. And it is a fixed payment of some sort. It's either a fixed hourly wage of $7.25 or $11.50 or whatever per hour, or it is a fixed salary of $30,000 a year for a particular time, and it is for defined services. That's why some of the lectures that we've done in the past are really, really important here, because the only way that we can really establish what the defined services are, and you see that's a really important part of the terminology, the defined services are indicated in the job description. So as we hire people and we talk about salary and payment, we're doing something here that we're going to talk about even again in another video. I think it's 10 or 11 perhaps chapter, where there is a contract that's being made and there is a trade-off. There is consideration is the term we're going to be using. So the trade-off is that you're going to do these defined services, these things, these essential functions during a given period of time, typically a 40-hour work week, in exchange for some payment and some benefits and things like that. So when we have an employee, we have a contract of sorts. You might not have ever signed a formal contract for a job in your life. I sign one every year as a professor in August or late July or something. I get an envelope in the mail from the Office of Academic Affairs, and there is a one-page contract in there that just basically says we're extending to you an offer of an employment for the next school year. And there are a few terms in there in terms of the salary and whatnot. There's always a disclaimer that if the state legislature has money problems, that they may be some furlough days, which have never come into play since I've been there. But down at the bottom it says if this is good with you, and it gives you the salary number, $60,000 or $20,000 or whatever your pay happens to be, sign here and send it back. There's a copy for you, there's a copy for the school. And that's a contract that's written down. You might not have ever gotten one of those, but even if you haven't gotten a written contract that you've signed, you still have had a sort of contract in that agreement that we're going to pay you $8.50 an hour in order to do these things. My daughter has a contract that not that she's ever signed, but there's a verbal contract. Basically, we're going to pay you this amount of money per hour in order to fulfill these functions in the job that we give you. So there's a contract of sorts, and it's either explicit or it's implicit. Explicit means that it's written on a piece of paper and it's signed by both people, and that becomes very, very much legally binding. There are very difficult opportunities to get out of that contract once it's signed. So we've got to be real careful when we have a written contract, an explicit contract. The other type of contract is an implicit contract, and this is important for test purposes. It is an unwritten contract, but it is nonetheless implied. How do we imply a contract that we don't actually have on a piece of paper or sign? Generally, the way that happens is that we make certain statements in the process of hiring that suggest a long-term relationship. So we might say, if we're hiring you to do something and we express your pay as $20,000 a year, well, that has just implied a year's worth of work. So we have to be very careful in human resources, and you learned this in your prior classes, that we express pay in terms of hourly amounts. Even if we're thinking of this person as a salaried employee, we express the pay in hourly amounts because we then have implied an hour rather than a year. So that's one way that we can have an implicit, implied contract. We can also have phrases that suggest a year in our handbook or in our documentation that they sign. So we got to be careful. Everybody has got some sort of a contract. We got to be careful about what the terms are in that contract. An employee, beyond being contract explicit or contract implicit, is either part-time or full-time, and depending on what our needs are and what our arrangement is with that employee, both of them are very common. Typically, when we think of somebody as an employee, we're thinking longer-term commitment, even if we're not committing to that up front. We don't typically bring somebody in as an employee for a very short period of time. They would fall into a different category, and we'll move on to those next. Another thing that's important to remember about employees is the concept of employment at will, and this varies from state to state. We've seen a trend lately that more states are becoming employment at will states. What employment at will states is that basically either you as the employee or I as the employer can stop this relationship at any point in time for just cause, there's a reason, or for no cause, as long as that cause is not illegal. And neither one of us will be held liable. So unless one of the exceptions that we have to this is if there is a contract in place. But generally speaking, in Georgia, in most of the Southeast, even somewhat now in the Midwest and the upper Midwest, Wisconsin just went to employment at will. It's not as common when you have unions, but it is relatively common when you don't. And what this says that in Georgia, for example, I can hire you and we can both kind of agree that you're going to do this particular job for this amount of money, and we both kind of go in assuming that this is going to be a fairly long-term relationship, although neither one of us has said that and committed to that. But 2 months from now, you can quit. And I would like for you to give me a 2-week notice, but you don't have to. And there's nothing really that I can do about it legally. If you want to quit, you can quit. But just like that, you can quit. I can tell you to quit. I can fire you. I can lay you off or terminate your employment. And I don't really have to have a reason for that. And you probably, if you've taken employment law, you have had some pretty good discussions with Dr. Wilson about whether I can fire you because I don't like the color of your shoes, or I can fire you because I don't like the fact that you grew a goatee. And in an employment at will state, yeah, realistically, you can fire somebody for any reason at all, even if it's a lousy reason. The reality is that you've got to be careful that you don't step on the border of discrimination, and that you can defend why you terminated. Because even though it's employment at will, if you let me go, lay me off, I can take you to court and sue you for unemployment and whatnot. And you, as the employer, have got to demonstrate that it wasn't punitive, perhaps that it wasn't discriminatory, and whatever. So what are the exceptions to employment at will? You cannot fire somebody and in the context of a retaliatory discharge. Retaliatory means trying to get even. So if you're doing things as a normal course of business and one of your employees goes to the newspaper and says they're doing this wrong, or they go to the police or the Fair Labor Standards folks, any of those kinds of things, and you complain or you whistle blow, they can't fire you because you blew the whistle. They can't fire you to get even for something that you did to them. They can't fire you to punish you for something, for making public and aware something that they did. So we can fire you for having red shoes on, but we can't fire you for having reported us for being unfair to our employees or our customers or whatnot. One context that this could come into play in is maybe in the medical field. If we are billing patients for services incorrectly, if we're billing them for seeing a doctor when they didn't actually see a doctor, if we're billing them for supplies that we never used, and an employee says, that's not right, I'm going to go and I'm going to tell somebody that we're doing this. That happens on a regular basis. And we cannot fire that employee for blowing the whistle on something wrong that we're doing. All right, so that's the first exception, is retaliatory discharge. The second exception is implied employment contract. We just talked on the last slide about explicit and implicit contracts. When our handbooks or our policies indicate that you're not going to be fired except for good cause or some very specified procedural process, then we got to be careful about the reasons why. If we suggest that you're not going to be fired, we've kind of nullified the employment at will. And we've also got to understand that the handbooks might have other phrases that suggest annual employment. Maybe even the concept of annual review. If we say something to the employee like, your annual review will be in November and it's January, maybe we have just implied that we're committed to keeping you until November. So we typically talk about those things in different phrasing, or we don't talk about them until October, so that we haven't suggested that we're committed until November. But exceptions: employment at will, retaliatory discharge, and implied employment contract. The other exception to employment at will is the implied covenant of good faith and fair dealing. And that means that if we ask you to do the good faith part of it, is that, and the fair dealing part, I guess, as well, is that if we ask you to do something that creates a real burden for you. For example, we've got we're based in Americus, but we've got offices in New York and in Phoenix and Los Angeles and so forth. And we come to you and we say, we want you to go do this project in the Phoenix office, and it's going to require you to move. It's going to be a several year period perhaps, and you're not going to want to maintain two houses. It doesn't make sense. So we understand that you're going to have to move, and we're going to help you with the costs of moving. That's great. Okay, I'll take that job. I move out to Phoenix, and then a week or a month later, the company notifies me and says, we've decided to end that project or end that position. Thank you very much. Based on employment at will, we're ending our relationship with you. And then I say, no, wait a minute. You forced me perhaps to move from Americus to Phoenix. I would rather be in Americus. I only did this move to Phoenix thing because of this particular project that you asked me to do in good faith. Now that I don't have this project, there's no reason for me to be in Phoenix, and I want to go back to Americus, and it's a hardship on me now to move back to where I started. So what we're saying in that particular example is, if we're asking you to do something that creates a hardship or a burden on you to relocate from your family to someplace, we can't let you go or terminate your employment until that project is really done, because we have in the process or the act of sending you and relocating you, we've kind of suggested we've got a plan in place that's going to have you there for a long time to make it worth the process of moving. Another example about good faith and fair dealing is that we have folks that have worked with us for a while. There is a point in time where, when they have worked a certain amount of time, suddenly they become vested in pensions or in retirement plans or in 401ks or things like that. In a lot of companies, it's a 5-year period. At the 5th year, you automatically get all the company money. Maybe for some folks, when you've worked here for 30 years, something kicks in, retirement plans kick in, and you get lots of money paid out. And we're looking through all of our notes, we're looking at our employees, the finances aren't real great right now, and it's like, oh my goodness, George over there is 1 month away from hitting this milestone, which is going to kick in all this money which we don't have. We need to go ahead and lay George off before he hits that milestone. That's not acting in good faith, and that's the only reason that we're laying him off. Then we have violated the employment at will, because we've terminated somebody's employment simply to avoid the vesting. An example that you might be able to relate to if you're a sports fan is that baseball contracts have typically lots of little clauses in there, and perhaps one of those clauses for a pitcher is that if you hit 200 innings pitched, if you're a starting pitcher, I mean that's a lot of time pitched in a lot of games. If you pitch 8 innings a game, then in the course of 25 starts, you've hit 200 innings. And maybe we say that if you hit 200 innings pitched, you automatically have a $5 million bonus kick into your contract. And so you get to be like 195. There's 2 weeks left in the season. And occasionally you read where coaches will decide not to let somebody play for a while. Now, partly because the reason they give is we want to save you for the playoffs and make sure you're fresh. But in a lot of cases, the reason is because we're getting dangerously close to having to pay you an extra $5 million, and we don't want to have to pay you that. So that's a violation of the fair dealing and good faith part of the relationship. So employment at will is something that you really want to understand. The general idea behind it is that you can quit anytime you want to. We can fire you anytime we want to, but there are certain stipulations that protect you as the employee that I as the employer, lines that I can't cross. So we have the first or federal or state discrimination protection laws that people put into place to protect you. We can't violate and still be in good standing with employment at will. All right, I think that's it. Right. So the first category of employees, of employment relationships, is employees. Those are the ones that you'll think of the first. Second category you want to think about is contingent workers. And a contingent worker is somebody who is in any job or role that doesn't have an implied or an explicit contract for long-term employment. Typically we have contingent workers when we have a particular job that needs to be done. It doesn't last forever, so we'll bring some people in to fill a particular role for a small period of time. But the way that we typically do that is not to bring them off the street and hire them. We go to some employment agency or contractor and say, we need a handful of people to do this. I remember back when I was in college and I was home one summer, or one December, January timeframe in between semesters, and I took a role with an employment staffing company, and every so often I'd get a phone call that would say so and so is looking to hire 4 people to work this week only, or Tuesday and Wednesday, and this is what you're going to be doing. And I remember one particular time there was a 2-day period where they sent me to a shoe store, like a Payless kind of thing, that was going out of business in that location. And what they wanted me to do, and 3 or 4 other people, the store was closed, there was nothing left in the front. We were working in the back in the stock area, and we were taking these boxes and we're putting them in big brown boxes that were going to be sealed then and shipped to some other store that wasn't closing. So it was 8 hours a day for 2 days, just taking these little shoe boxes and putting them into bigger boxes and sealing them so they could be moved. And that was a contingent worker kind of situation. I was working for the agency, and it was for a specific purpose for a very limited period of time. It helps us from an employer standpoint to get some people as we need them that we don't have a long-term commitment to, but to get a particular project done that's only going to last for a short window of time. So employees and contingent workers, but also temporary workers. They are similar perhaps to contingent workers in that they are used for a short term or for specific assignments. But generally, they're only for a certain period of time. That's what short term means, I guess. They're supplied by an agency. The agency is paying them $8.50 an hour, and they're charging us $12 an hour. So we pay basically their employees' pay or their fee plus some sort of bonus to the company that gave them to us for a limited time to cover some of their overhead. It's important to remember when we're talking about temporary employees that we can, because they're not our employees, we don't have as much control over them. We can tell them what needs to be done, but in a lot of cases we're limited as to telling them how to go about doing it. You've got to get these boxes of shoes in this big box so that we can ship them, but I don't really have the authority to tell you to do it this specific way. You can do it any way you want to as long as this outcome gets achieved. Temporary workers are very much like, in a lot of cases, contingent workers. Leased workers are still not our permanent people, although they tend, and so they're similar to contingent and temporary, but they're longer term. A contingent or a temporary worker might only be a couple of days or a couple of weeks, a couple of months perhaps. A leased worker might be several years. And it's common in certain roles and industries. IT folks can be leased out for long periods of time to maintain networks. A leased employee might be somebody who is working for a janitorial company that comes in and cleans your office, and they're going to be doing this for the next year or two. But like temporary and contingent, they don't work for you. They work for the people who sent them to you. So that company pays their salary, that company pays their benefits, that company pays their unemployment taxes and so forth, and their matching Social Security and whatnot. And we as not the employer, but as the company that's using them, pays a fee to the leasing agency that covers not only their salary and their benefits, but the overhead for that company. But it's easy for us then, even with their long term, to say, listen, we don't like these people, send us some different ones. They don't work for us. We don't have to go through the process of trying to manage all of that kind of stuff. The next kind of employment relationship is a seasonal employee. This is typically for a very short-term situation. It's a little different than a temporary worker, because a temporary worker might be 2 days for a specific task, but a seasonal worker is somebody that's generally working, generally speaking, a couple of months, but it's the same point in time of the year every time. So it might be an amusement park. We talked in one of the other videos about how Six Flags will hire a whole lot of people for the summer, but they're not going to employ them the rest of the year. It's for the season of the summer, or for the season of Christmas or December or the holidays, where we've got a higher volume than normal. And it's very common at certain times and not at others. The next category is the independent contractor. That's somebody who performs services, kind of like the contingent. You remember, we as the employer is not the right word to use here, but because we don't have other terms that we can use that are similar. Think about the company or the organization. That entity to the relationship, the company or the organization, can tell you what it is that you are to do, but it can't tell you how to do it. It can tell an employee how to do this particular thing to receive this particular outcome, but for an independent contractor, they are free to do it any way they want to. And it's very important, as you see in the sub-bullet there, to classify these folks correctly. Because if we have folks that we're calling independent contractors, we're not paying their benefits, we're not paying their taxes, we're not paying their Social Security. They're responsible for that on their own. It's a little different in that sense from the contingency and the leased workers and so forth, because those people do actually work for some company that's paying that stuff for them. The independent contractor works for himself or works for herself, doesn't have a staffing agency that they go through, so that person has to pay not only his or her Social Security tax, but also the company match, because they work for themselves. They're their own business. But where we don't have to pay their taxes and benefits and things like that, we save that amount of money, so it's a benefit to us. If we have somebody that we're calling an independent contractor, but we are telling them not only what it is that they're trying to accomplish, here's the goal, here's the project, but here's how we want you to do it. We're treating them like employees, but calling them independent contractors, and we can get in big time trouble because we're classifying them wrong, and we should be paying their taxes and so forth for them. The last sort of employment relationship that we're going to talk about and then therefore in this particular video is the idea of outsourcing, and that's where we hire some other company to do it for us. So we don't have to hire the employees. We don't have the responsibility of unemployment and workers' comp and taxes and so forth. It's typically done with clerical functions like cleaning and food services, maybe administrative assistance perhaps, or recruiting in the HR function typically is always more commonly done as an outsourcing. We don't want to do the recruiting and go find the people. We're going to hire this company to do it for us and just talk to the people that they send us, and we've outsourced that function. That is it. As you see, there's only 13 slides here. Just a list of types of relationships. From a testing standpoint, you probably want to make sure that you understand that explicit and implicit contract, that you really have a pretty good understanding of the at-will relationship, and that you kind of understand that seasonal employees are like December or the summer or so forth. And one of the main things that you really want to make sure that you understand is the idea of the independent contractor, that we can control what they're doing, but we cannot control how they go about doing it. So if we want to bring somebody in as an independent contractor, we've got to give them the freedom to do it whatever way they want to. And we can't then go back really and say, well, I wish you'd done it this way, because it's up to them because they're an independent contractor. That's all for this particular lesson. We will close the video on Chapter 3A and start gearing up emotionally for 3B. We're making progress towards the end of the semester, and I hope that you're learning a lot of good information that you can take with you in days to come as you go out into the real world. Bye for now.